so I don't want you to feel like you're rushing or anything. So, does that work? Yeah. Okay. Okie dokie, everybody. Welcome back from break. I would like to introduce our next speaker, Jennifer Ruby, our public access counselor. Yay!
Hi there. I'm going to go through some of this stuff relatively fast, and some of it we can slow down on. I'm okay answering questions, but if I start running out of time getting through everything, we may need to put a kibosh on that. Okay, so we're going to talk about Indiana public access laws. This is my disclaimer. The presentation is designed to familiarize you with the concepts, not to include every exception for application. My deputy asked me to put this in here as another attorney. So review the statutes and or discuss with your attorney to develop positions or specific responses. The legislative intent was to make things more open, to make government more open to the public so they can understand what's going on, make it more open and transparent. So the Open Records Law, or the Access to Public Records Law, is shining a light, allowing people to know what's going on in their government, to feel more a part of it, and to make sure that they're not getting disenfranchised in the process. The Public Access Counselor's Office has all these duties. Number one is to do education and to train public officials on public access rights and responsibilities of public agencies under the public access laws, like access to public records and open door law. Now, I've highlighted the last three because they're ones that have more, either are new or have more oomph under House Bill 1360. And so the way I'm going to do the presentation is to kind of do open door law and access to public records generally. Then we're going to go into House Bill 1360 to show you what's changed. And then we're going to kind of wrap up with some general things as well. But now I am supposed to, in my annual report, make recommendations to the General Assembly concerning ways to improve public access. That wasn't spelled out anywhere before House Bill 1360. Another thing is there's going to be 2 new reports that we're going to need to get from everybody. But it's to track the volume and nature of public records requests created or received by public agencies, identify patterns and sources of excessive automated phishing-related or data scraping-based public record requests, and to establish a standardized mechanism by which the public agencies can report suspect public record requests. There's going to be 2 kinds of reports that are going to be required. One is going to be the 7-day, basically within 7 days, and we'll get into this more with House Bill 1360, but within 7 days of getting some kind of questionable request that you want to decline or deny, you need to report that to our office so that we know about it. Theoretically, that will help us see that a certain individual is trying to hit all the agencies so that we can maybe let you all know that it's going on. It also might trigger us to be able to say something to the legislature to say, hey, we need to deal with this a little bit better. The other one goes into more detail beyond that, and it's an annual report that we're currently asking to be done, like you close it May 31st, and then you submit your report between June 1st and June 15th so that our office can submit our report to the legislature on June 30th. Now, I said all that, but that's next year. We're trying to get it all up this year so that you know what we want you to give us next year. And we're working with IoT to develop a bubble that's got guidelines, the specific statutory additions, and then the 2 different records reporting mechanisms that we've got. Now, both of those are going to require Access Indiana access, but I'm hoping you already have that because of Gateway or other things that you use in the state for whoever is going to submit those. A little more than I planned to say there, but I wanted to let you know a little bit more since I was talking about them here. Our office receives thousands of requests for assistance annually. We get phone calls, voicemails, emails, postal mail, hand delivery, and just my email box, which I kind of equate with the PAC email box because there's a lot of stuff that gets sent to me that really should have just gone generally into the PAC. Those two email boxes get somewhere between 50 and 150 emails every day that we need to deal with. We're also supposed to conduct internal and external education trainings, presentations across Indiana. Now, one of the things that I always have to say here is to be clear, because we're quasi-judicial and we're going to make rulings on complaints and write opinions, we are not supposed to give legal advice. So we may refer you back to your attorneys. We may give you statutes and then also tell you to go talk to your attorneys. Your attorneys can call us and we can kind of discuss things, but we can't give you legal advice that you rely on and then have that information come back to us in the form of a complaint, because we didn't get quite all the information we needed from you in order to give you the opinion that we gave you. So then we can't write an opinion. So that's why we can't give legal advice. All of our opinions and our annual reports are found on our website. And the reports are try to file with the General Assembly by July 1. First, open door law. Oops. There we go. This basically means all meetings that we have should be open to the public so the public can sit in and see what's going on. Watch government in action, so to speak. Some basic rules you need to consider are the majority, governing body, official action, and public business. You've got to have all those kinds of things in play in order for it to be required to have an open meeting. And the definitions are pretty clear, and I was telling somebody earlier, we need to sometimes step through what is a public agency. If it's not required by a public agency, is it required by a governing body? Now, if it meets those two, then was official action taken? And official action can be as simple as receiving information or making recommendations. And then public business, was it actually public businesses being discussed? Because we had one where somebody sent in a complaint where the majority of the council was at a church and they were discussing what they wanted for the community and the church. So it was kind of like a brainstorming session. Well, that was a church and the way the church was going to do it. Just because they happened to be a full or a majority there, they weren't discussing public business per se. They were discussing what they wanted the church to do, and they were discussing it with other church members. It didn't circumvent the process or anything like that. And I do understand that it could have an appearance, but that was not public business. That was church business. You usually have to have 48 hours notice, must be open to the public. Now, last year I went around and talked to people about, when I could, about live streaming. Live streaming began July 1, 2025, and some governmental entities are not following it still. We don't have a whole lot of complaints in our system about that, but I think we just did one. We just issued one. I'm just not sure if it's up on the website yet. So basically, the executive, legislative, or fiscal bodies of the state, county, city, town, or township levels need to stream their meetings. No one else under these bodies needs to, and we get lots of questions. Well, this is what my organization is. Do we have to do live streaming? No, unless you are holding your meetings in one of those bodies that are already live streaming. If you don't have internet access where you meet, then you're supposed to record the meeting and post them to your webpage for 90 days. It can be destroyed after 90 days if you want to. If the technology fails for any of the meetings, you are not going to be penalized, but you should try to comply. Consistent non-compliance is not a good way to be open and transparent. But we have had somebody submit something where they didn't do it right, or 30 seconds were missing. Well, people explained they were having trouble with their internet and it didn't all get recorded. So they weren't penalized. This does not remove the need for agendas, meeting notices, meeting minutes. All of those requirements still apply at all levels. And this information is for public meetings. If it's a public hearing, those have potentially different statutes, so it's not covered here. There may be more stringent. For instance, most public meetings do not require you to take public comments. Public hearings would be a different story. Those require usually public comments. And so there's additional technology that's required in order to do that, especially when you're live streaming and the person isn't in the meeting. We worked on guidance and got that published June 6, 2025. There's guidance on the IoT website as well as our website. Currently, it is the second thing smack dab in the middle of our website. But pretty soon, hopefully at the end of this week or next week, we'll have two bubbles. The bubble on the right side will be for House Bill 1360, and the bubble on the left will be related to live streaming. But right now, live streaming's the second thing on our website. The required notice is still 48 business hours, have to have date, time, place, and then with House Enrolled Act 1509, disclosure of appointing authority, which also happened last year in 2025, you have to add more. You've got to put in, which is on the next slide, additional information about the executive people in that group. So generally, no requirement to publish in a newspaper. Public hearings are different than public meetings. Annual notices are permitted. And by that, I mean a lot of times people will go ahead and publish once a year in December what their whole meeting schedule will be like for the year. Emergency meetings are the exception. Most post at the principal office of the public agency. If no principal office exists, then you post it at the meeting location. Usually, website or newspaper notice is not sufficient. You have to actually physically post it. Special meetings of county executives are under 36228 and must state specific subject matter. And then we still have a prohibition on serial meetings, which will come up in a later slide. The 2025 changes to notice or agenda because of House Enrolled Act 1509 are: any board meeting notice or agenda must provide the following information: officer's name, appointing authority, beginning and expiration date of the officer's term of appointment. This information should be on the agendas, in the notices, and they should be on the website. So here's an example of a public meeting notice. And there at the bottom, you've got president, vice president, secretary, and treasurer. I just used elected because I figured that would be easier than trying to figure out appointing. But like if you're appointed by the city county council, instead of elected, it'd say city county council appointment. And then you put the term and duration. Executive sessions. They are the exception to meetings that are open to the public. You still must notice them within 48 hours ahead of time. They must include the statutory purpose for excluding the public. Then afterwards, the meeting minutes or memorandum must include certification that only topics permitted under the open door law and posted in the notice were discussed during the session. So it's not going to be meeting called to order and all this other kind of stuff. It just says this certifies that the meeting took place and only these subjects were discussed. It should be irregular, not very often, but they were expanded in the 2025 legislative session. Still a requirement that no final action can be taken in those meetings. So some of the changes that happened in House Enrolled Act 1134 in 2025 are: it adds employment-specific compensation and employment matters, but it does not apply to general discussion of salary compensation or benefits. It also added to discuss employee health care options with respect to special exceptions for coverage and employee handbook changes. It also added to review negotiations on the performance of a publicly bid contract when the public knowledge regarding the review would cause a likelihood of increased costs. We want to keep costs down, so if we think if the public being involved is going to increase costs for whatever reason, we don't want them involved in some of these discussions or negotiations. To discuss soliciting proposals for the purpose of awarding contracts for goods and services when proprietary data, trade secrets, or other information is contained in the bidder's proposals. or unique methods of conducting business or determining prices or premiums to be charged for the services under the terms of the proposal, and public knowledge regarding the discussion would reasonably be expected to result in private loss to the providers of the information described in above. So those are the new additions to it. So there's 18 or 19, I think there's 19 different reasons that you can do an executive session now. So this is what an executive session would look like. You do notice of executive session, where it's located, the reason, and you still have to put, because of the other change, the officers' information and how they were involved in what their term of office is. Common executive sessions are subject matter, records classified as confidential by federal or state statute, alleged misconduct of an employee, strategy with respect to pending litigation or litigation threatened in writing, to receive information and interview prospective employees, and then various other justifiable executive session subject matters. They're all there, statute 514, 1.5, 6.1. Virtual meetings, I get this question every once in a while. When COVID hit, there was a public health emergency, and so completely virtual meetings were allowed. So if there is a public health emergency, you need to go to that statute. If no public health emergency exists, then basically remote participation is allowed if 1/3 of the membership is present. And boards can craft policies to internally regulate procedures for remote participation. And here's the serial meetings slide. Generally, serial meetings are not allowed, and the reason people potentially would do a serial meeting is to avoid open door law. They want to discuss something and try to figure out what their stance is before they go to a public meeting. It's not allowed. So the first one says one of the gatherings is attended by at least 3 members, but less than a quorum of the members of the governing body, and the other gatherings include at least 2 members of the governing body. I had somebody actually ask me if they could do something like this, and I told them no. And then I pointed them to an opinion that very specifically explained this. The sum of the number of different members of the governing body attending any of the gatherings at least equals a quorum of the governing body. All the gatherings concern the same subject matter and are held within a period of not more than 7 consecutive days. The gatherings are held to take official action on public business. And remember, official action can be as simple as accepting information or making recommendations. There's about 4 or 5 things there, but I'm not sure that that's in this slide. All you have to do is go to the definition of official action, I believe, in the statute. Miscellaneous open door law considerations. As I said earlier, there's no right to speak under open door law unless another statute requires it. Here the example is given as public hearings, but I believe they also changed it for school boards. There's no right to participate by the public. Minutes or memorandum are subject to it. We did change our stance a little bit because I believe Luke said all meeting minutes, even if they're draft, are public documents. We agree that they are public documents, but we also consider them to be potentially deliberative. Because I used to be on a couple different boards, and I found that sometimes the meeting minutes required, and approving them required a lot of changes and a lot of discussion. So once they're approved by the board is when I think they are final. Electronic meetings of state agencies, no secret ballots when voting. Access to Public Records Act. As you'll see there, public records mean everything. So if you get texts on your personal phone that are public business, those are going to be subject to APRA. Doesn't mean anybody's ever going to want them, but they might. It also doesn't mean that you're ever going to have to release them because They could be deliberative, they could be attorney-client confidential, or they could be just strictly private where you're telling somebody, hey, want to have lunch? The public doesn't need to have that information. But I want to make it clear because we've gotten a recent complaint about something similar. So texts, emails, everything can be a public record. You've then just got to look to see if there's an exception to it. What is a reasonable period of time? All records must be provided within a reasonable period of time after the request is received. Let me back up just a second here because people also misconstrue 24 hours versus 7 days. If you are given an in-person, if somebody calls you or shows up in your office and they give you a records request, you have 24 hours to tell them, to acknowledge it and tell them that you're either going to work on it or you're just going to deny it. You have then a lot of time to actually get the documents ready. Just because it was 24 hours, that's a 24-hour acknowledgement. Same thing with the 7 days. If you get it by email or postal mail, you have to acknowledge that you received it within 7 days. If you can tell them that you're going to go ahead and deny it, that's great. But if you're going to work on it, then that's just an acknowledgement, and that's the 7 days. You have more time to get them the rest of the information. And there's lots of people that complain to our office that I sent this request in 7 days and I didn't get my documents in 7 days. Well, we are going to kick them all back if somebody makes a complaint like that because we're not even going to consider them unless it's been 30 days. If you did a denial, we'll look at it. If you didn't do a denial but you also didn't get them the records yet, then we're not going to look at it or even consider it until at least 30 days have lapsed because you have time to get them the records. Another thing associated with this is I had somebody that had a not reasonably particular request who felt like this database access should have been able to get to him really quickly. He called it a 2-minute lift. I told him, I'm sorry, sir, I disagree with you that it is a 2-minute lift. It is not a 2-minute lift. They have to get those records. Then they have to review those records and decide, do any of these exceptions apply? And then after they've made their determination of what they think you can have, they usually send it to legal. And then legal's got to take their time to see if there's any reason that you shouldn't get those records. So it is not a 2-minute lift. Almost never is it a 2-minute lift. Maybe if somebody's requesting meeting minutes, is it a 2-minute lift? Because those have already been approved. Okay, so factors to be considered. How broad is the request? Where are the records located? How much redaction is necessary? Is it a busy time at the agency? Election boards, if you can't get to it at the time of election, we'll understand that. What we like to see is communication, status updates, time, and then like a timeline to give them information, potentially piecemeal disclosures. If it's a really big records request and it seems legitimate, then you have time to get it to them and you just tell them you're going to try to get them 30 documents every Friday or something like that. I mentioned reasonable particularity. The requests from the public must be reasonably particular, which is a subjective standard. Questions to consider are, can you find it? Are there objective elements in the query? What we like to see are no blanket denials and cooperation to narrow the requests. Now, when you're talking about emails, we want to see a sender and a recipient. We want a reasonable time frame, often, per my predecessor, no more than 6 months. And then there should be some kind of key word in there so that we have an idea what we need to look for. We've had some people send APRA requests that they want all my emails since I started office. Well, then somebody else said, all my emails that contain the word APRA. Most of the emails that I get contain the word APRA, so that's not reasonably particular. But you need to have those kinds of factors in there, and we have some case law to support that or in our opinions. So if you search reasonable particularity on our opinions website, you should be able to come up with some recent opinions related to it, especially with those factors. Three categories of public records: disclosable records, confidential public records, and discretionary public records. I'd actually call this disclosable records, mandatory exceptions, and discretionary exceptions. Disclosable records are meeting minutes, budgets, invoices, receipts, RFPs, contracts, anything received in an open public meeting. And when I say open public meeting, I mean somebody actually did a grievance against an employee and submitted it in an open public meeting. Now, normally, something like that would go into the employee file and would not be considered a public record. But this gentleman did everybody a disservice by submitting it in an open public meeting, and because it was submitted in an open public meeting, it's technically a public record. So discourage or try to tell them that you will not accept it if that is the case, to try to keep it part of the employee's record. Confidential public records: personal health information, confidential financial information, trade secrets, student records, social security numbers, and those declared confidential by state statute or federal law. I had a thought and I lost it, so if I come back to it, so. Sorry, there's confidential records. Discretionary public records, investigatory records of law enforcement agencies. Not that you, I'm guessing you might not need this, but body cams and dash cam recordings, those are law enforcement recordings, and they are an exception to this exception. They can be brought back in as an investigative record, but they aren't on their own when they're originally recorded, an automatically investigatory record. Attorney work product, client communication, deliberative material, personnel files for public employees. And there are exceptions to the personnel files. You're allowed to give them their work address, some of their background information as far as employment history. So there are some things that you can give out of the personnel files, but there's a lot that's not. Emails, a public record includes electronic media, must be available for inspection and copying by the governing body unless an exception to disclosure based on content applies. Like I said, there's a lot of exceptions that once you review it can come out of there. And it must be maintained within the records retention schedules. And that's another important piece to remember is not employment, but just the record retention schedules. Recently we had somebody get mad because there was an email from an old employee who I think maybe forwarded or just FYI'd something that was negative from some past committee. Well, that employee left state government 15 years ago, and emails are only required under the retention records to be maintained for 3 years. He tried to say that they were hiding something. And then the IT department had shifted programs, so some of the old records that even if they can be found now couldn't be found because of the change. So retention schedules can be your friend. If it's not something that you need to retain, it's okay, because there's a retention schedule so that we don't keep paper forever, or electronic files, as the case may be. Okay, 2026 changes to APRA via HEA 1360. House Enrolled Act 1360 passed during the 2026 legislative session. Governor Mike Braun signed it on March 4th, 2026, and it became Public Law 97-2026, and it takes effect on July 1st, 2026. So just in a matter of a couple months, less than 2 months. Now you have the ability to create electronic portals, or it's kind of recommended. You're allowed to set up and maintain the electronic portals to accept APRA requests. It's already written into APRA that you can create your own form of how you want to receive APRA requests. This kind of bridges that gap and says electronic forms are okay. But one of the other things with the electronic portals they want, or you want to be able to check to see whether the requester is human, verify the requester's physical address, and determine whether the requester is an Indiana resident. For those of you dealing with sovereign citizens, and people who like to make anonymous requests, this could be very helpful for you. Now, sometimes here I get questions about the electronic portals. The state did APRA portals for 54 different agencies, and it cost $573,000, so they spent about $11,000 per portal. Some a little more, some a little less. IoT is willing to do this for local governments and charge a fee to set up, as well as an annual maintenance cost to be determined. But people often ask me, how much does this cost? And so there's one example. Here's another example. Tyler Tech has a national FOIA contract, and the state could move all of our APRA portals to them, but that would cost $500,000 to $750,000 to move now 56 portals. Then the annual maintenance would be another $200,000. For local governments, if they wanted to use this technology, it would be somewhere between $5,000 and $15,000 to set up and $2,000 to $5,000 annually to maintain. Just wanted to give you an idea for those of you who might be interested. Now you can decline requests if you believe it is related to data scraping, which I generally was calling data aggregation. If they're a data aggregator, there's companies out there that are getting swaths of purchasing data so that they can then advise and give that information out to other people. If it's phishing, or if it's an electronic transmission that could jeopardize the public system or the public data. If you decline an APRA request, then you must notify our office within 7 days via online reporting. So make sure it's a valid request and not phishing. Phishing is the fraudulent practice of sending emails purporting to be from a reputable company in order to induce receipt of information. So can you verify the sender by calling him or her back to discuss the request? Is the company a legitimate company? Is the URL for the company legitimate? Does it contain a hyperlink? Our IoT does not want us to click on any hyperlinks that are received in email for file transfer protocols. So that was the hugest red flag in this, which I'm hoping they will send out a full copy, a PDF of this, so you can read this, because you can read it better when it's on your screen. But this is an example of one that we received in May, and several state agencies received it, and several counties received this. But basically, Mike Vichich is an actual tech guru, but he does not have this company. There is a company by this legitimate name, but this is not their domain name. They also are not located in Ann Arbor, Michigan. So there were several red flags in this email, and several different versions of this email circulated. So that's an example of a phishing email. A new change in 2026 under AGA 1360 is pending litigation. This is E under, under 514.3.4A are all the mandatory exceptions. B are all the discretionary, and when I say discretionary, I mean your agency gets to choose whether or not you want to release the information. So this is E, and this is if a person made a request who is a party to a pending or ongoing litigation and it just duplicates a discovery request, then you can decline or deny their request. Now, I had no problem with this because if there's a complaint that's sent to our office, we can't give an opinion if there's pending litigation. A conflict between the executive and the judicial branch wins. So I like this, but I also know that I gave a couple presentations last year and people were having problems with the fact that they had pending litigation over here, but they were driving them crazy with APRA requests. So they were duplicating it, and they said, can we just deny it? And I said, it kind of depends. You can tell them that there are opinions from our office that says if there's a discovery request, in their inter-court proceeding, the discovery request is where they should be going. But we also have a lot of per se litigants, and they don't understand the discovery process, so we try to sometimes work with them with APRA requests. This clarifies it and basically says if they have ongoing litigation, you don't have to do their APRA requests because they've done it. They should be doing it through discovery. You're now allowed to charge supplemental fees to non-Indiana and out-of-state entities. They must be reasonably related to fulfilling the request and may not be more than 25 cents per page or $25 per hour of staff time. You can still waive the fee if the agency finds that a request serves the public interest. And an example of that would be if a university is trying to get information because they're looking at all 50 states. That's a case that's out of state that you might consider waiving the fee. Priority status. It gives public agencies the ability to prioritize fulfilling requests. Indiana residents and civic, journalistic, academic, or personal use can take priority. Out-of-state and automated entity requests may be delayed as needed to avoid disrupting core functions and may be subject to the supplemental fee. So you can slow them down and charge them more. And again, here's reporting. Public agencies will need to submit 2 kinds of reports to our office. The first is notice of incident report for any request that is declined as automated, data scraping, or phishing, to be submitted within 7 days per that statute. Second is an annual summary report of the type and number of requests received throughout the year, as well as a summary of data reported. That's pretty much it for House Enrolled Act 1360. So back to denials. Denials can be done orally or written. And if it's written, you need to make the denial in writing. If it's orally, you may do it orally. You can also do a written version. If it comes before the trial court, the burden is going to be on the agency to demonstrate the denial complied with APRA. Also, the court may review the records in camera and may review records if without the redaction, so they can see what happened there. And in camera means that you'll go back and talk to the court and they'll do it, so it's not part of the public process. But they can review everything to see whether or not they agreed with you. Non-compliance, consequences. Complaint to the public access counselor, or a lawsuit, or both. Penalties, court action seeking order to produce and potentially order to pay attorney's fees. They're more likely to get attorney's fees if they've submitted a complaint to our office and we've sided with them. If that's the case, I would probably go back, re-review it, and possibly try to get them the records before they filed suit. Under IC, unless your attorneys still say you think you're right. Under IC 514.3-9.5, personal liability for public agency, officer or management level employee, there can be fines for knowingly and intentionally withholding of public records or violation of the open door law. Now, I had somebody recently tell me that they were worried about this provision. It's a very diligent person, so I really doubt that he would ever knowingly or intentionally. So that's the standard, knowingly and intentionally. It's a pretty high standard. It's not negligence. It's not a lesser standard. It is knowingly and intentionally. So if you purposely withheld information from somebody when you knew they should have access to it, you can be penalized under the statute. The other penalty is getting bad press and damages to your public perception, your office's public perception. Now, some common misconceptions of agencies. You can offer to allow them to inspect, but that's not often sufficient. You often need to make the copies or do more to help. Everything can be redacted. Everything cannot be redacted. As this example shows, the only thing you can understand in that is no snack car. Denials do not have to be explained. They do have to be explained. You can reference lacking reasonable particularity, but usually our office considers if you tell them that they lacked reasonable particularity, that's an invitation for them to submit a better request rather than an outright denial. But you can deny them for confidential, those are confidential records, that's attorney-client privilege, that's a deliberative document, that's an investigatory record. You can tell them that. You don't even have to tell them necessarily what specific documents that you're withholding, but you can tell them other documents were withheld for this reason or that reason. Okay. Any document containing confidential information may be omitted from public records response. Where something like this happens, you can sometimes redact and still disclose a document. So you need to scrutinize some of these documents that are confidential. Is it all confidential, or can you provide some of the information? One that has come through a couple different times are settlement agreements. If it's a public document, if the public agency is settling with somebody and paying them money, some of those provisions can maybe be redacted, but you can't redact the bottom line. You can't redact the dollar amount that you paid them in many cases. Now, if there's a federal component or another component that comes into play that makes it mandatory, you might be able to. But just because you say that the settlement agreement is confidential, if you're a public agency, it doesn't necessarily mean it's confidential completely. Common misconceptions of citizens. A public agency should answer questions under APRA. You do not have to answer questions or provide additional information that they did not ask. Information is usually not an APRA request. It has to be for an actual record. Give me immediate access. We are not Google. Our primary purpose is not APRA. Our primary purpose is to protect the public, do the budgets. Mine is, but I'm trying to think. Fix the streets. That's the primary purpose. It's not APRA. So immediate access is not the way that this is. If it's immediate access, then that's stuff you put up on your website so that they don't have to call you and make an APRA request. Keep public records forever. Again, use your retention schedules. Know what they are for you, the records that you're maintaining, and use your retention schedules. Handle public records requests before handling other matters of the public agency. Again, no. You're there to do your work. You're not there to answer public records requests. We want open and transparent government, but that's not the whole purpose of government. The purpose of government is the actual work we have to do. Keep public records in a format that is most convenient for me. No, if they want it in a format that is convenient to them, that might be enhanced access and that might be subject to an additional fee. Again, my disclaimer, this presentation is designed to familiarize you with the concepts, not include every exception for application. Review the statutes under discuss with your attorney to develop positions or specific responses. And there's my contact information. And there's my question slide. So, questions?
Over here. I have several questions, and this may be helpful for others as well.
What am I looking
We have, on a regular basis, before our meeting, we have a, I'm sorry.
Oh, there he is. Because her hand was up, so I didn't see you. Sorry, go ahead.
Okay. You'll know my county without me saying it by some of these questions, so you're very familiar with some of our residents, or maybe not residents. Anyway, we have a finance committee meeting with 3 of our council members. Prior to a meeting, we review the agenda and we make sure we just review that there's enough funding to make any decisions that's necessary. Is that a serial meeting, considered a serial meeting?
Did you only have one meeting?
We have 1 meeting a month before the regular meeting.
And what's quorum?
It's 3 members of the council and myself. 4. I'm sorry? 7 members on that.
So you have a pre-meeting before your meeting.
Just to review the agenda, yes, and the finances on the agenda.
Yeah, I don't think you should be doing that.
Okay, we will change. Thank you. No, it's been something that has been done. I'm always under pressure about transparency things, and one of the things that council packets, so information that we send out to the council before a meeting, is that public records.
Is that something that we currently have a complaint on?
I probably bet you do. So let's move.
It sounds like something that we've discussed.
Let's move on.
I think I have a complaint on that, and I can't remember how we came down. Okay.
Don't worry. You'll figure out the county soon. What about posting claims?
Sorry, what?
What about posting claims? I've checked with the other auditors in an email earlier in the year, and we found out that most people do not post claims in any public format. But one of our commissioners has decided to take the claims that they sign off, and he posts them to a Dropbox. The problem I have with there is that there's sometimes there are jurors' names on there and other things that should not be posted. Who is supposed to be responsible to monitor that?
Okay. In general, I would say you need to talk to your attorney about potential liability for doing something like that. Because just because you can put it up on the web doesn't mean that you should. A lot of my predecessors, especially early on, they would post the complainant's name, their address, and that kind of information, and sometimes an email address. And I started initially doing that, but then I was like, if I want to post this on the web, I'm going to redact that. So then I redacted it, and then we've just done a position where we don't do that. So you have to think about what some of the public repercussions could be for doing that. And you also sometimes need to be aware of personally identifiable information. I'm not sure that we have a statute specific on it, but there's a state handbook on personally identifiable information. And a lot of times, all you need are 2 minor pieces of somebody's information in order to steal their identity. So talk to your people and try to see what you think makes the most sense for your county.
Moving on.
Okay.
We have, and you're very familiar with this person, made specific requests on how they receive the information. So they turn around and they ask for over 200 documents over a 2-year period, and then they want it digital. And that's not quite possible unless we're taking the time to actually, because some things are just hard copy, and some things are not because of the change in the way we record our claims now, where it's the bills, and they were asking for copies of invoices. And so are they allowed to dictate what format they receive it in? And I kind of look back at that last page there and thinking, I already know the answer is no.
They're not really allowed to dictate it. It's
Okay.
It's more of a matter of customer service, whether you want to do that. And then, like I said, sometimes it's to the point that that's an enhanced transaction fee.
And I'll make this my last question, and thank everybody else for being patient with me on this too, as well as you. We have an ordinance that says that every page copy is 15 cents. Somewhere on the state, it says it should only be 10 cents. We believe local ordinance rules because it's our costs, not what the state costs are. So we've been in battle. The person refuses to pay it, so I refuse to turn over the documents.
Okay.
I have a second question. If somebody says who requested the information, then when I call them to tell them it's ready, they said they don't want it anymore.
Okay. It didn't make it into these slides because they were more generic, and I only had an hour, and I wanted to make sure I got in House Bill 1360. But in the statute, it does say that you can estimate the fee up front and request payment up front, so that you're not doing a bunch of work and then the person never picks it up. As to the 10 cents versus 15 cents, that's something I would have to look at, because our general stance has been that the state says under APRA 10 cents. And so where that kind of comes up is when police reports are $8 or $15, but they're only 3 pages, so it should, under APRA, it should be 30 cents. Now, if somebody's really claiming it under APRA, then technically they should get it for 30 cents. But the insurance companies, everybody else who wants that police report, you can charge them the full fee because they're not necessarily claiming APRA. So there might be that kind of a distinction, but I'd have to look to see what else we have there, because we've not done, especially when it's 10 cents versus 15 cents. Okay, who else? Okay.
So I just wanted to go back to your reporting, and this is for 2026, so I'm assuming that this is effective as of January?
It's effective July 1st.
July 1st,
So
okay.
starting July 1st, if you get, because I had somebody send me an email this week, we denied this because we think it's data scraping. And I was like, okay, that's good, and I'm okay with that, but the law doesn't take effect until July 1st.
Okay, so the second is this annual summary report.
Uh-huh.
So I have been keeping track of our requests for my office, but not for everyone else's. So are you requesting this report as a countywide report or for an independent department?
It depends on what you guys decide you want to do. That's when they asked us to do this, we were trying to figure out how many we might get. And SBOA does it a certain way because they look at the whole county. Whereas most people contact us individually by their we get calls from the treasurer's office, we get calls from the auditor's office, we get calls from, just different offices. So there's nothing that dictates what that is. Also, IoT said that it'll be interesting to see what kind of reports you get because of the fact that IoT, everybody's supposed to be letting them know when they've had some kind of cybercrime happen on their system. And they said they only got like 200 reports. So people aren't necessarily reporting it. So I don't know what kind of reports. And I think in the first couple of years, I'm not going to get as many reports. But we list in there, and that's why I want it out so that we can start having these conversations, because you don't have to submit it to our office until May of 2027, or you don't have to submit it to our office until June of 2027. So I want those kinds of conversations to happen so people can come up with a plan. I'm fine if each county office sends us a report.
I would just like to say, as the elected official for my office, I would like to be responsible for my own report and not anyone else's. So I don't know if there's going to be some type of jurisdiction given to the executive body that would say that they're allowed to make us do that or not, but that's probably what it would take for me to try to do everybody else's report.
Well, and that's why, like I said, I'm not necessarily saying that you would need to do that. I think what we'll do is we'll see what we get in the first year and summarize the data and see if we need to make other recommendations. But like I said, I know when I talked to SBOA trying to get a handle on how many people, because I thought SBOA might be the closest, and then they told me they did the whole county. I'm like, well, I get more than just one county report, one county person talking to me. So we could get up to 7,500 potential, reports that come in. But it's electronic, and it's going to be dumped into an Excel spreadsheet, so that'll be helpful for me. Who else? Okay.
So we have a situation in our county where I get complaints several times about the meetings after the meetings.
Mm-hmm.
So I get the request to leave the live stream on until a quorum is broke, because I do know there's a lot of meetings after the meetings. Is that something we should practice till a quorum's broke? But if I've been in a situation where I started doing that last year, and then all it did is create controversy with myself and my commissioners. So what's your thoughts on that?
I would say talk to your attorney, because
Our attorney's in our commissioner's pocket, so that really doesn't matter.
well, but then you'll have make them give you an opinion on that,
that was
so
recorded,
that
wasn't
whatever
it?
you're following helps cover you. But we found with live streaming, one of the things that nobody contemplated is accidental release of personal identifiable information like social security numbers, or accidental release of public health information or confidential information. So we've suggested in situations where you think that, and it's mostly hearings, you think that kind of thing is going to happen, have an executive session to discuss those things first and get them out of the way, and then have your meeting. But you're going to have to notice both of those meetings. Now, keeping the live stream up, that's going to be a matter of public preference, but theoretically, once you adjourn, you adjourn. But we did have, I do think we had somebody that there was a meeting before an official meeting, and then there was another sub-meeting before the next meeting. And two of the meetings were noticed properly, and two of the meetings weren't. And so we had, I believe we dinged the public agency because they were having meetings outside the public. And keeping up live streaming maybe could help with that, but it's also going to document that. So that's why I think you should talk to your attorney and get them to come up with some real parameters around that. Okay, where now? Okay.
What is the recommendation when an executive session is held for a specific person? As the auditor, I'm doing that, the brief minutes of memorandum. What if they talk about more than what the topic for the executive session is? Is the auditor to note that or just pretend it didn't happen?
Well, I can't really speak to that. What I can say is that they're not supposed to talk about anything other than what is at the executive session. And when they make a certification, their certification states that that is all they talked about. We have had some complaints on that, and I think we've ruled different ways depending on the information that we receive from both sides. And sometimes they do a mea culpa too.
So does the auditor who's doing the minutes or the memorandum note it, or do they just note that the topic advertised for the executive was discussed? I mean, it puts the auditor in a bad position, or whomever is taking minutes, in a bad position because you can't stop what they're doing.
That's more of an attorney question. You need to talk to your attorney. How do I handle this when this happens? And maybe they can help that to stop happening.
What I can tell you, Jacques, is when I had to staff, when I used to, for about 14 years, I was the city attorney for the city of Bloomington, and when I would have to staff executive sessions, if I heard members straying, which they love to do when the doors are closed, they're like, great, now we can talk about anything, you just jump in and say, stop. And I don't know, the auditor's role for the council and the commission is more as the secretary, but if you hear things straying, I would not, it would be appropriate for you to speak up, I think, to say, wait a minute, I thought this executive would be appropriate. This executive session is supposed to be only to discuss this personnel matter, right? It's not supposed to stray over here into the budget. So I don't want to usurp, but that's the experience that I personally had. Jennifer is the final authority on this, but.
Now with these added categories for the executive sessions, in my county anyway, and we're a growing county, so there's some needed conversation when it comes to administrative things, employees and salaries and such. As the auditor, are we required to sit in those administrative meetings like we do executive meetings?
Are you required to? Is that what you asked?
Well, there's usually somebody that's supposed to be there to kind of attest to what that meeting was about. So I don't know. Are we supposed to be there like executive meetings or no?
When you say administrative meeting, what do you mean by administrative meeting?
Well, my commissioners are saying, they're calling the administrative meeting some of the new categories, discussing their employee salaries and those types of things.
Okay, because there's different things. If you're talking about an executive session where they're talking about the salaries and things, if it's an executive session and you're supposed to be there, then I think you should be there. There are real administrative function meetings which don't have to be public noticed. Some people call them work group meetings. And they're basic meetings that are going on just to do the daily functions of running the organization. And those are open to the public, but there's no notice requirement. They can be.
They're
You
Can
can't
they
kick
not
somebody out.
be? Can they not be open to the public?
If they're administrative function meetings, they should be open to the public. It doesn't mean you notice them, you don't necessarily tell them, so nobody's necessarily gonna show up. But you can't kick them out if they showed up because they found out there was an administrative function meeting going on. It's a weird animal in there, but if it's an administrative function meeting, it has different rules.
I think I saw one more question at the front, and then I think we're going to be over time. Or maybe it was at the back.
Okay, I'm going to stand up for this because this is with all due respect, and I'm sure there's a lot of auditors that feel the same as me. We need assistance. Constant telling us to get with our lawyers is not, or our attorneys, is not working. So we need some type of guidance on this with public access. My commissioners are continually meeting in a quorum and conducting business and then coming into a meeting and voting on it with no discussion. I have sent several emails. Public have sent several emails because, and it puts us auditors in a situation where we're the babysitters or the mom of the county. So you've got our public who we work for coming to us upset about the way things are going on and wanting us to fix it, but yet we have nowhere to turn. Where we're saying, okay, I've notified, the attorney's not doing anything. I've sent emails to public access, and nothing's being done.
We're trying to get through as many complaints as we can. Our office contains myself, my deputy, which I was finally able to hire in August 18th of last year, and I have one staff on loan from another office through an MOU. And we got over 498 complaints last year, and there were things in 2024 that were not dealt with, and we've already over 250 complaints this year already. So we're trying to get through it, but we're doing the best that we can under the budget constraints and the fact that we cannot hire anybody else in our office. So we're trying to answer as many of the emails and calls as we can get to them, and we're trying to get through all of the complaints. And some of the complaints are really easy, some of them are really easy to reject, and some of them are more complicated because we have to do some research, especially because the way the office has changed, we can only make our decisions based on statutory law or Indiana case law. So some of the opinions of my predecessor don't necessarily stand up. So we're doing our best to work with what we've got. And I'm trying to get out and do training, but because of the fact that we need to get these complaints out, I have to still do the training very sparingly because I need to have my behind in the chair issuing opinions.
Don't want to take up too much more of Jennifer's time, so I would like to thank her for coming and attending. Jennifer, are you going to stick around just in case they want to ask questions? Okay, so she will probably find her way in the hallway, so if anyone has more specific questions they would like to ask of her, she will be sticking around. We are going to talk appropriations and encumbrances for the next 24 minutes.